So I want to thank you all for coming. There are few more special parts of the job than celebrating our colleagues. Each year we have a lecture named for Austin Scott. There's not many people in this room who know Austin Scott or knew Austin Scott, but Louise Zubro is here. Louise, where'd you sit down? Louise did know Austin Scott. Apparently, in addition to being a noted scholar in the faculty, he was also a great tennis player. And he was also beloved by his students. And so we look to one of our colleagues who is doing exciting scholarship and is beloved by his or her students. And you'll see we have had many of these lecturers, and we have many people in the audience today who've given them over the years. And this year, it's my great pleasure to welcome Carolyn Ramsey, who has for years been doing very interesting scholarship, weaving together criminal law, history, looking at women in the criminal justice system with a very interesting eye to identifying stories, trends, and insights. I very much look forward to what she has to say. She's put a lot of thought into this effort, and we'll invite you all to join us afterwards to celebrate her in a reception next door. So without any further ado, I introduce Carolyn Ramsey.
Good afternoon. Thanks for coming, and thanks to Dean Weiser for inviting me to give this lecture. Early in my career, I did a study of prosecutorial discretion in homicide cases in late 19th century New York City. I analyzed these cases to see when the district attorney was most likely to accept a guilty plea to a lesser offense than capital murder. And in doing so, I made a surprising discovery. The type of defendant who was most likely to get the most severe treatment, that is, a defendant who would be charged with first-degree murder, prosecuted in front of a jury, convicted, and sentenced to death, tended to be a man who had killed his wife or girlfriend. This was a remarkable finding for several reasons. First of all, it presents a stark contrast to today, when a domestic killer like Scott Peterson, who killed his pregnant wife in California in 2002, is an anomaly on death row. Second, my findings about these homicide cases in New York fit uncomfortably with my own feminist understanding of the criminal law. I had always accepted and taught the well-established feminist narrative, which holds that the criminal justice system has historically treated men's homicide of their female intimates leniently, excusing these cases as provoked manslaughter at the worst. This common narrative further suggests that police and prosecutors long ignored wife beating, which gave abused women no recourse against their violent husbands in criminal court. In contrast, when women killed their husbands or boyfriends, they supposedly got the book thrown at them. No matter how abusive these men had been, the women who killed them could rarely make successful self-defense arguments. They were forced to plead insanity or face a capital murder conviction. Or so the story goes. This narrative is theoretically appealing because it fits well with the feminist meta-history of sex-based oppression, and it has been politically useful in bringing an important social issue, intimate partner violence, into the spotlight. But after my initial foray into these New York homicide prosecutions, I spent several years researching and writing about intimate partner violence in the United States between about 1850 and 1930. My research suggests that the standard feminist narrative is incorrect, or at least overstated. In fact, during the time period I studied, wife beaters were arrested or summoned to court for domestic assaults. If convicted, they had to pay significant fines, spend time in jail, or both. Their violence was condemned not on feminist grounds, but because they failed to fit the prescriptive ideal of the male breadwinner who protected and provided for his wife. There was no effective deterrence policy, but police and prosecutors faced some of the same frustrations they still do today, including abused women's reluctance to participate in the conviction and incarceration of their batterers. Wife beating sometimes escalated to murder. Men used lethal violence to punish their wives for separating from them or having affairs. But these cases weren't treated leniently in the criminal courts. Rather, male defendants faced conviction and even the death penalty for killing their wives. They were convicted of first-degree murder in most cases. In fact, the provocation doctrine provided a much less reliable avenue to mitigation for men than it does today. Male defendants were rarely acquitted of wife murder, even though they were prosecuted in front of all male juries. Yet, when women killed their male intimates, they often did obtain acquittal, or at least mitigation to manslaughter, and this was possible in part because self-defense theories worked better for women in the past than scholars have often recognized. Women didn't always have to claim insanity to escape conviction. Because divorce was stigmatic and legally difficult, and there were few employment opportunities for women, juries must have understood that abused wives had few options aside from staying in the violent marriage. They could establish a relationship with another man, but only at the risk of physical retaliation from their husbands, and they might be able to scrape by at the few jobs that were available to women at that time. But they still would have had challenges with regard to child care and child custody. Juries must have known that such women felt cornered and trapped, and that they sometimes used lethal violence to protect themselves. As a result, female defendants in the past were usually acquitted or punished for lesser crimes than first-degree murder. Dusty criminal case files in county courts and other archives around the country showed that this was true. Scholars who have only focused on appellate material have missed these women's stories because their cases didn't go up on appeal. Now, some of you in the audience may be shaking your head and thinking, I remember a time in the 1960s, the 1970s, even the 1980s, when police turned a blind eye to intimate partner violence, and when it was very difficult for women accused of murdering their husbands to raise successful self-defense arguments. You may have been someone who helped these abused victims when nobody else would, or you may be an intimate partner abuse survivor yourself. So what happened between the 1930s and the later decades of the 20th century? I hope to answer this question in my book. For now, I just have a hypothesis that I'm researching. Here's what I think I may find. As the 20th century progressed, women gained a political voice and the ability to get a full-time job, though often for lesser pay than men. By the 1970s, they could get a quick no-fault divorce on demand in most states, though with lesser prospects for alimony than in the past. The backlash against women's employment and against popular divorce led to disease theories of why marriages fail that often blamed women for intimate partner violence. So women simultaneously appeared less sympathetic to police, courts, and juries, and more capable of taking care of themselves. They lost the paternalistic sympathy of the public and the legal system. The why didn't she leave question became a big impediment to self-defense and other legal arguments that women formerly had made with success. Today I'm going to use a series of cases to show why the feminist narrative about historical sex bias in the criminal law needs to be revised. Then I'm going to describe in more detail my hypothesis about how the system became less sympathetic and more punitive towards intimate partner violence victims as the 20th century progressed. I'm going to talk for about 35 minutes, and then I'll welcome your questions and comments at the end. This material is part of a book in progress, so I have plenty of time to take into consideration your suggestions to make it better. This collage from the Los Angeles Times shows 2 Los Angeles police officials and a prosecutor who advocated the public flogging of wife beaters in 1908. Many law enforcers seem to have shared their view that a man who beat his wife was worse than an animal. Police Chief Kern, he's the big guy in the uniform, said there's no excuse for a man when he stands up and strikes a woman. No excuse in the world. The police captain on the lower left, I know it's a kind of a small picture, but this police captain declared, a man who strikes a woman is no good at heart. If he does it when he's drunk, he's doubly a beast, and if he does it when he's sober, there is no punishment hard enough for him. The LA Times article accompanying these images reported scores of wife-beating cases in 1908, attributing such violence to Americans rather than so-called foreigners. The public whipping of wife beaters was authorized briefly in California in the 1870s, and some other states, including Oregon, also had whipping post laws. But the most common punishments for domestic assaults were fines of $50 to $200, which by my estimate was about $1,300 to $5,300 in today's money in 1900. Many Californians who inflicted physical injury on their wives were incarcerated for several months, and they could face prison sentences of up to 2 years if they used a deadly weapon during the assault. Studies of police responses to intimate partner violence in the 1970s indicate that officers commonly just walked violent men around the block or referred their victims to social service agencies. By contrast, my research shows that in the 1870s, or just 50 years ago, or 50 years earlier than that, as recently as the 1920s, when this headline ran in the LA Times, such men would have been hauled into police court. These domestic assault cases crossed class lines to implicate otherwise respectable families. Wealthy men, professionals like lawyers, even members of the clergy, as well as the working class and the chronically unemployed, could be convicted for wife killing. The few husband beaters brought into court were generally released. In fact, men whose wives beat them became targets of ridicule. Although police and prosecutors tried to deal sternly with wife beating, their approach was a failure. Recidivism may have arisen from insufficient punishments. That was the diagnosis that the Los Angeles police chief made in 1908. But intimate partner violence was a complex social problem. Criminal punishment for wife beaters often conflicted with the preferences of abused women, even if they had initially sought the state's protection. They may have wanted the criminal justice system to teach their spouses a lesson through pretrial detention, but longer-term incarceration imposed serious costs on the family in terms of lost wages and likely physical retaliation. The police and courts seem to have recognized this dilemma, which provides a fairly benign explanation for why non-custodial sentences were so common for misdemeanor assaults. The reluctance of abused women to use the criminal courts also impeded convictions. From the mid-1800s through the early 20th century, charges against batterers were sometimes dropped or reduced if their victims declined to give evidence. Victim recantation might lead to acquittal if the case went to trial. Nevertheless, the state sometimes pursued domestic assault charges in the face of victim non-cooperation. For example, in 1871, when the wife of Theodore Costor appeared with a severely beaten face in a San Francisco court, but said she didn't want to prosecute her husband, the court refused to allow the dismissal of the complaint. Police officers took the stand to testify about beatings that they'd witnessed, and judges in other cases sometimes even jailed victims for contempt for refusing to cooperate with the prosecution. For example, in 1922, Elise Leclerc, who's the woman mentioned in this headline, spent a week behind bars in Los Angeles for refusing to give any information to prosecutors about her husband, who was charged with shooting at her 5 times. The state thus intervened more strenuously in violent families than scholars have previously recognized in the late 19th and early 20th centuries. I'm not arguing that such intervention was as aggressive as under today's mandatory arrest or no-drop prosecution policies. It wasn't. But I still think it's remarkable and an important corrective to common assumptions about the past to discover not only that men were brought into criminal court and charged with wife-beating, but also that judges sometimes refused to dismiss criminal complaints over the victim's objection or even imposed contempt sanctions on beaten women who refused to assist the prosecution. One aspect of intimate partner violence seems to have been a historical constant. Abusive men use violence to control their partners, and that violence is most likely to escalate to murder if the woman tries to separate from the man, to leave the relationship. The historical change I want to emphasize is this. Unlike the law in many modern jurisdictions, the criminal law of the late 19th and early 20th centuries refused to recognize a woman's attempt to leave a man as legally adequate provocation, unless she committed an adulterous sex act that the husband actually witnessed. In 1912, the New York Court of Appeals stated, "Adultery gives no license to either of the offending parties. And if a man deliberately, after a lapse of time sufficient for his passion to subside, kills either his wife or her lover, it is murder in the first degree." This man, John Osmond, shot his wife Mary and her lover to death in New York in 1892 after suspecting their affair for several months. Mary was trying to leave him, and she alleged in the divorce papers that he had beaten, bruised, and bitten her. Osmond was convicted of first-degree murder and executed in the electric chair after the district attorney refused to accept his guilty plea to first-degree manslaughter. If Osmond's case had gone to trial in New York in the later 20th century instead of in the late 19th, he might have raised an extreme mental or emotional disturbance defense and received a lighter sentence for a less serious type of homicide based on his claim of emotional instability. In countries whose law derived from the English model, including the US, the provocation doctrine eventually underwent dramatic expansion. It became more subjective. In the United States, a substantial minority of jurisdictions even adopted the extreme mental or emotional disturbance doctrine, which eliminated the need to show provocation and justified emotion, as well as the cooling time restriction, which historically had precluded a man from claiming provocation if he killed his provoker after a lapse of time. Today, we're willing to sympathize with a man whose emotions simmer and slowly reach a homicidal boiling point. We're willing to extend mitigation even if his victim didn't do anything wrongful or to anger or upset him. Now, Colorado is a little bit different. Colorado actually still has quite rigorous homicide laws on the books that take cooling time into account in grading. However, the sympathy that many states, at least 20, including New York and California by many estimates, now show to male perpetrators of intimate partner homicide contrasts with the law of the late 19th and early 20th centuries. The Victorians deemed self-restraint to be a masculine virtue, and condemnation of men whose jealousy and desire for control led them to stalk and kill women who tried to leave them was something that was condemned in Victorian times. And this continued for several decades after the Victorian era had officially ended. John Osmond went to the electric chair, as did men who killed female intimates in other parts of the United States, and even in states where the use of the death penalty was not so prevalent, these men still received severe punishments. In 1911, for example, a judge refused to give jury instructions on provocation and insanity that this guy, Gus Marshall, requested. Marshall was convicted of first-degree murder for killing his wife when she ran away with another man. Men who stalked their victims often tried to claim temporary insanity or intoxication to make an end run around the limits of the provocation doctrine, but as in Marshall's case, such strategies were rarely successful. Men charged with murdering their female intimates came from all social classes, but the press, and perhaps juries too, seem to have reserved special distaste for men who didn't live up to late Victorian values, men who failed in business, engaged in drinking and other vices that showed a lack of self-restraint. This newspaper drawing depicts Martin Loppy, an unemployed tugboat fireman who was convicted of stabbing his wife to death in 1890 and executed the following year. The New York Herald described him as a small, repulsive-looking man. I think he actually looks fairly dignified in this cartoon, but maybe the cartoonist was being generous. Another newspaper noted his peculiar shrinking gait. And the New York Appellate Court that affirmed his conviction reported that Loppy was dissipated as well as idle and had no means of obtaining the money necessary to enable him to indulge his vices except from his wife, who had a few meager earnings from her sewing. In other words, this domestic killer wasn't a real man by the standards of his time. My research thus indicates that the state began to take a more active role in policing the family earlier in history than scholars have previously thought. We need to rethink the separate spheres paradigm because although the 19th century is often seen as the heyday of the private family, the domestic murder and assault cases that I've studied show the state intervening to enforce an ideal of the private family and of bourgeois masculine identity, but they certainly don't show a stark contrast between the private world of the family and the public world of the state. Instead, in these cases, the coercive power of the state was brought to bear on family disorder in the form of criminal punishment. I'm now going to talk briefly about 3 types of cases against female defendants. First of all, cases involving women who killed their abusers during a physical confrontation and were able to obtain acquittal on classic self-defense grounds. The second category encompasses cases involving non-confrontational homicides of abusive men who were killed during a lull in the pattern of violence, when they were sleeping, drinking their beer, doing something other than assaulting the female defendant. These were the most difficult cases to defend, as they are today, and they often resulted in convictions for manslaughter rather than murder, especially if the prosecutor could pin some other vice, such as drinking or sexual promiscuity, on the female defendant. But even in the non-confrontational cases, women were sometimes able to get favorable court rulings allowing evidence of past violence to give the jury a context in which to place the alleged murder. When this happened, the case could be transformed by a skillful defense lawyer into my third category of female defendants' cases, which I've called the honor killing category. Acquittals for honor killings also arose as a matter of jury nullification when judicial rulings favored the prosecution. The honor killing category encompassed female defendants who went free because they killed men who violated prevailing norms of masculine behavior. This last category of acquittal included women who had been physically abused by their partners, though not at the precise time the alleged murder occurred. These women sometimes argued self-defense, but their acquittal required a sympathetic relaxation of self-defense doctrine that went beyond the boundaries of formal law. Under the gendered moral code of the time, the honor killing category also included jilted or abandoned women who killed in desperation or anger at the predicament in which their male partner had left them. The case of Bridget Waters, a California woman acquitted of murdering her husband in 1888, provides an example of my first category, a confrontational killing that resulted in a classic self-defense acquittal. Bridget Waters had tried to separate from her violent husband, Patrick, but he followed her around and tried to get her to give him money whenever he thought she had it. While she was living in LA, she learned that Patrick had come to town, and she begged a police officer to arrest him. The police officer went in search of Patrick, but Patrick still showed up at Bridget's boarding house and assaulted her. A couple of other guys threw him out, but he followed his estranged wife when she went on a shopping trip and threatened to shoot her in the street. Bridget claimed she shot him in self-defense, and the judge allowed her lawyer to introduce a mountain of testimony showing that the deceased had repeatedly threatened to kill her in the past. Evidence of this past violence was admissible because Bridget claimed that Patrick had pointed a gun at her immediately before she shot him, and her prior abuse gave her reasonable grounds to shoot. Hence, her attorney had no need to depict her as insane. She was acquitted of murder and released. The second category of cases, the non-confrontational homicides, involved women who killed male intimates who were not attacking them at the precise time of the alleged killing. Past violence alone couldn't justify a self-defensive killing under the formal law. The threat had to be imminent. So when Norma Pumphrey killed her husband in Denver in 1913, the trial judge reminded the jury that Norma's frightening past experiences with her husband Charles had no bearing on the question of self-defense. Right before his death, Charles and Norma apparently got into an argument about some chickens, but there's no evidence that Charles physically assaulted Norma at the time. The instructions depicted her as an excessively nervous and timid woman, rather than the reasonable person required by black-letter law. Yet despite these unfavorable instructions from the bench, the verdict was manslaughter rather than murder, and Norma Pumphrey was sentenced to just 9 months in county jail. Even if female defendants were found guilty of murder, however, they were almost never executed. For example, one of the very few women sentenced to death for killing her spouse in New York in the last 2 decades of the 19th century, Chiara Cegnarali, became the focus of a successful petitioning campaign that resulted in the governor granting clemency, in part because Chiara had been abused by the deceased, her husband. By contrast, a similar petitioning campaign on behalf of a male medical student named Carlyle Harris failed to prevent Harris from being executed for poisoning his wife. The man depicted wearing the sandwich board in this cartoon on behalf of Harris, trying to drum up support for gubernatorial clemency, was an anomaly in men's cases. Cases of men who had killed their female intimates rarely attracted this level of support from the public. If male prisoners were spared their full sentences for intimate partner homicides, they usually had the parole board to thank. Thus, Fred Aguilar served 15 years of a life sentence in California for murdering his wife after she allegedly had an affair. He was released after 15 years from San Quentin Prison in 1924. In the eyes of a more sympathetic judge and jury, female defendants like Norma Pumphrey and Chiara Cegnarali might have been acquitted for killing husbands who failed to live up to prescriptive ideals of masculinity. The Los Angeles Times commented in 1886 on the unwritten law in every American community that holds a woman guiltless who, in the desperation of her sorrow or in the face of a dishonored life, sheds the blood of her betrayer. I found the unwritten law at work in a couple of types of cases involving female defendants from New York to California and in places in between, like Chicago and Denver. First of all, the unwritten law exculpated women in cases of seduction, abandonment, and emotional cruelty. Pregnant girlfriends jilted at the altar, or wives whose husband abandoned them with hungry children to feed, could commit lethal violence and still escape conviction. More importantly still, in cases of physical abuse, courts, and especially juries, looked at a wider time frame around the killing in assessing self-defense claims by women. The unwritten law thus became a safety net for female defendants whose cases didn't fit the narrow grounds of formal self-defense doctrine. Both of these types of cases, the emotionally abused and abandoned women on the one hand, and the battered women who had weak self-defense claims under the formal law on the other hand, fit under this extra-legal rubric, which I've called honor killings, which were as a concept that was at work in the late 1800s and early 1900s. The Talbot case in Nevada in 1910 exemplifies the way the unwritten law might exonerate female defendants who didn't clearly face an imminent threat of death or grievous bodily injury at the time that they killed their abusers. Opera singer Mae Talbot met her husband at an attorney's office to discuss their divorce case. During this meeting, an altercation ensued, and Al Talbot hit Mae. Mae then fatally shot him with a pistol that she had concealed in her fur muff. At the murder trial, Mae testified that Al Talbot had a long history of physically abusing him. The night before she killed him, he beat her so severely that a doctor was called. However, even though there was some kind of confrontation in the lawyer's office, the blow Al struck right before Mae shot him would not have been deemed life-threatening unless his cumulative physical abuse of her were taken into account. Under formal self-defense doctrine, the defendant's lethal act has to be proportional to the harm she faced. A simple assault didn't justify homicide. At Mae's trial, Judge Pike gave a jury instruction to that effect. But Judge Pike also reminded jurors that under the laws of the state of Nevada, a husband has no right to physically chastise his wife. He further stated that if the jury found that Mae had killed her husband, they could take into consideration the fact that the deceased was a man and the defendant is a woman. Although self-defense law is often seen as a sexist doctrine designed for fights between men, Judge Pike invited the jury to see that law in explicitly gendered, albeit paternalistic terms. The jury acquitted Mae Talbot in a single ballot after a 45-minute deliberation. Mae Talbot's case was anomalous in that her trial became a media sensation that attracted press coverage on both coasts, as well as, of course, in Nevada. It was quite a sensation in the Sparks and Reno papers. Her talent as an opera singer and the relatively lax divorce laws on the books in Nevada compared to other states might have made her seem more independent and less trapped in her marriage than other wives accused of intimate partner murder. But her acquittal still harmonized with similar outcomes in the cases of ordinary women, women who weren't celebrities and didn't have good career prospects like Mae Talbot had had. Women like Ruby Conley, the pregnant wife of a furniture polish manufacturer who shot her husband to death in the garage of their home near San Diego, California, while the police were on the scene responding to her domestic violence call. Ruby's case received just a few incomplete lines of reporting in Southern California papers, but the criminal court records confirmed the outcome in 1922, acquittal on a self-defense theory. How and why did outcomes in intimate partner violence cases change in the second half of the 20th century? Or did they change? I'll need to confirm existing claims in the legal and social science literature that the deck was stacked against women in the police departments and criminal courts of the later 20th century. Because I'm still researching this part of my book, I can only offer a preliminary hypothesis that despite the paternalism of the late 1800s and early 1900s, obtaining justice actually became more difficult for intimate partner violence victims as the 20th century progressed. Changes in employment opportunities, divorce law, and psychosocial understandings of intimate relationships combined to create a false sense of the ease with which women could exit an abusive marriage. This overestimation of women's ability to leave, paired with a new view that women didn't need to be protected in outmoded Victorian ways, contributed to a waning sympathy for victims of intimate partner violence, especially when they stood trial for killing their batterers. At the same time, the criminal law of excuses expanded, giving male defendants a better shot at obtaining acquittal or at least mitigation for barely coherent, emotionally disturbed violence against women that certainly would have led to a murder conviction in the late 1800s and early 1900s. The first change that I want to mention is the transformation of divorce law from a 19th century regime that made divorce an adversary procedure, available only on a few limited grounds, and that presumptively awarded custody of the children to the father, to a regime of no-fault divorce on demand by the 1970s. Mothers also began to get custody of their kids, first under the tender years doctrine and then under the best interests of the child analysis, and laws relating to the dissolution of property at divorce also changed. These developments were gradual. They began with trial courts succumbing to pressure from divorcing couples to bend the law to fit the facts. Divorce had become more appealing due to new ideals of companionate marriage based on mutual satisfaction rather than duty. Reformers also touted the ability of divorce to provide an escape hatch for women whose husbands abused them. By the 1920s, the grounds for divorce based on extreme cruelty had been expanded to include emotional cruelty in the majority of states. By the 1930s, many states had altered their statutes to allow divorce based on incompatibility after a specified period of separation. In 1970, California became the first state expressly to adopt a no-fault divorce statute. There were 700,000 divorces in the United States in 1970, compared with just 380,000 in 1950, and a mere 10,000 about a century earlier in 1867. The advent of easy divorce was paired with two other gradual developments: the rise of women's employment in the public sphere, and a social and psychoanalytic backlash blaming women for the demise of traditional marriage. The world wars created unprecedented job opportunities for women, and both proponents and detractors of divorce saw it as a largely female institution sought by working women who could support themselves. The new women's independence was belied by socioeconomic reality, though. Women generally received low wages, lacked affordable childcare options, and were constantly at risk of being fired to make way for male breadwinners. Moreover, as feminist Crystal Eastman noted in the 1920s, breadwinning wives have not yet developed homemaking husbands, and responsibility for raising children still lay exclusively with women, whether or not they worked outside the home. Women were criticized for their greed if they sought alimony on divorce, yet their actual ability to feed themselves and their children if they didn't remarry remained precarious. The backlash against women's employment and against popular divorce also encompassed psychological theories that depicted failed marriages as disease-ridden and women's mental and emotional instability as the root of the problem. The therapeutic divorce movement of the 1950s focused on getting the couple to reconcile by signing an agreement to maintain a gendered division of marital duties. The wife would take care of the housework, childcare, and meal preparation, while the husband would do exterior maintenance on the home and yard and provide for the family financially. Legal and social science experts viewed wives who refused to reconcile by signing such agreements as sick or even mentally ill. And women also began to receive the blame for intimate partner violence. By the 1950s, the theory of male brutishness, common among the Victorians of the later 19th century, had been almost completely supplanted by a victim-blaming focus on female frigidity and the failure of beaten women to satisfy their husbands sexually. According to theories derived from Helena Deutsch and Sigmund Freud, battering was punishment for the wife's failure to fulfill her proper role in a gender-based system. Other theorists linked women's violence against their male intimates with hysteria, the tendency to associate the female partner not only with the busy docket and divorce courts, but also with irrational violence against men, influenced the popular media, as this 1948 cartoon from Collier's magazine shows. Of course, the final shape of divorce reform jettisoned the therapeutic model in favor of individualistic, no-fault divorce. But a couple of legacies remained. First, a tendency to overestimate women's options for exit and self-support at a living wage in a society that had yet to grapple effectively with employment discrimination. Feminist family law scholars such as Marianne Glendon have argued that far from giving wives an easy exit, new laws governing the dissolution of property at divorce actually resulted in the impoverishment of many working class and middle class women, especially older ones. A second legacy of the struggle over divorce reform was the tendency to blame the female intimate partner for the physical and emotional abuse she might face in a relationship. This medicalized victim blaming dovetailed with the rise of psychological excuses for the types of homicides that men most often commit. And unfortunately, even after the advent of the battered women's movement, psychological theories, especially the battered women's syndrome theory pioneered by Lenore Walker, have dominated efforts to defend women charged with violence against their batterers and to explain why they often recant their prosecution testimony when their batterers stand trial. It is paternalism of a different type in a society that now purports to embrace gender equality and that has won many important victories against sexism on other fronts. Our modern reliance on battered women's syndrome evidence is well-intentioned, and it is often a very practical litigation strategy that leads to successful outcomes. But ironically, it may give abused women less opportunity to explain their actions in rational terms than they had in the late 1800s and early 1900s. A lot of legal scholarship is being generated right now in the law schools around the country that focuses on the way the state intervenes and uses its coercive power in the family. But both proponents of the aggressive criminal prosecution of batterers and scholars like Jeannie Suk at Harvard Law School, who tend to be skeptical or even to oppose such intervention in the family, have assumed that it's a new development in contrast to a long history of non-intervention in which the family was deemed to be private. My work calls into question this dichotomy of family and state, thought to have existed in the past. From the 19th century through much of the 20th, the state intervened in the family to preserve an ideal of separate spheres. But the home was only treated as a sanctuary if both husband and wife played their proper roles. When they didn't, they were called into account in the criminal courts. At least up to 1930, most of this intervention seems to have been aimed at men who failed to live up to norms of physical and financial protection of women. They were prosecuted for assaulting their wives and, at the extreme, for murdering them. Whereas women's use of self-defensive violence against their male partners was often deemed justifiable. Somewhere around the middle of the 20th century, the tables seem to have turned, and women's bid to work outside the home was blamed for the demise of the traditional family. But in the late 1800s and the early 1900s, in a society influenced by an unstable synthesis of Victorianism with the limited claims of the first wave feminists, police and prosecutors struggled to prevent and punish intimate partner violence. They encountered some of the same challenges and frustrations we still face today. The common narrative about the state's supposed tolerance for intimate partner violence in the past may make us feel good about our presumptively more enlightened policies, but we need a more nuanced and accurate history, which is what I'm trying to achieve with this book project. Thank you, and I welcome your comments and questions. Yeah, Amen.
Thank you so much, Carolyn, for presenting your work. It's really very interesting. Clearly founded in a great deal of top-notch research. I guess the question I have goes to the relationship between intimate homicide and homicide generally. Mm-hmm. And more particularly, how the dynamics in homicide as a broader category have changed over the same period of time that you're looking at these changes in the context of intimate homicide. For the obvious reason that that speaks to the value or the weight of the inferences that you can draw from that from that research.
Mm-hmm. Well, you know, obviously, the 19th century was quite a punitive time. In 19th century New York, there was a mandatory death penalty for first-degree murder, so it's not so surprising that people convicted of first-degree murder were executed. However, juries often tended to sort of resist finding that someone was guilty of first-degree murder because they didn't want to send someone to the gallows. And so one thing that I did find interesting in the cases that I studied is that there tended to be sort of a reluctance on the part of juries in general to convict people of first-degree murder, especially in New York where it was a capital crime. But that, reluctance didn't seem to extend to the cases of the domestic killers. And I find that very interesting, and it indicates to me that, there was, a special condemnation for men who stepped outside of their Victorian role and used violence against their female intimates. Yeah, Chris?
I also enjoyed the talk. I love hearing a bit of history because we don't get enough of that. But I was very interested in something at the periphery of your talk. You commented about the battered woman syndrome and how that might give a woman less opportunity to come forward with arguments and I'm curious to know what lay behind that comment.
Yeah, I mean, it certainly is sort of at the tail end of the time period I'm looking at. I'm not quite sure what role it's going to play in the book, because I almost see the book as going up to the battered women's movement and not going beyond it. But, it's an interesting and problematic situation, because obviously the battered women's syndrome evidence was pioneered as a way to secure acquittals for women, or, if the woman is a prosecution witness, to explain why she may become recalcitrant on the stand. And so it's quite pragmatic. And it also, the way I understand the Norma Walker theory, it's not meant to depict the woman as irrational. It's where it fits into the litigation is to show why the woman did what she did. So it's really a reasonable person in the battered woman's shoes. I think the problem with it is often it sort of defaults to a shorthand, where the message that the jury may receive, the message the public may receive, the message the judge may even send, if he has kind of an unsophisticated understanding of the evidence, is that she was simply irrational. And that's why we have to see her actions as different than what we would expect, because she essentially is suffering from post-traumatic stress disorder. So, I think if you are careful with the way you state the law, it's a way just to contextualize objective reasonableness. But I think the problem is often that gets lost in the shuffle, and the message that's actually sent is that these women behave in pretty much pathological ways. And that's my concern. And that's the contrast that I'm raising, because although certainly there was a lot of talk about women's hysteria in the 19th century, I think surprisingly in these self-defense cases, the women were allowed to explain in pretty much rational terms without any psychological evidence why they committed the murder that they did.
Just a little follow-up. I agree with
Yeah.
all the things you said. I think it certainly is not intended to suggest irrationality. The thing that you see, I think, most often in the cases is the suggestion that the general public lacks an understanding of the domestic circumstance and needs to be enlightened by expert testimony, in effect explaining and providing a rational basis for the woman's behavior. One of the things I always wonder is, how much longer are we going to go on saying that when there's been a huge amount of public conversation about all of this stuff?
I think that's a wonderful point. And just quickly, I mean, the book is not meant to be normative, and so it's not going to make a lot of legal reform proposals. But I do think, that there's hope that we're reaching a point societally where there's more public understanding of the issue, and where also some kind of social framework evidence may be able to be brought to bear that doesn't pathologize the abuse survivor, but rather, give some information about the lack of a social safety net. I mean, some of the same factors, that I talked about in the lecture about the woman's lack of options for exit persists today. And I think that kind of information can be useful to a jury. And maybe that's something that the public is coming more to understand in 2011, one would hope. But yeah, Aya.
So thank you very much for this paper. I, of course, love your work, and I think it is a brilliant insight to argue that Victorian norms actually have this unusual effect of making the police more responsive and jurors more responsive to intimate partner violence rather than less responsive. And I would also say it makes logical sense that with the advent of liberalization in divorce and women's liberation, you might expect the opposite effect, that maybe now, we'll have some backlash. Police and jurors will be less responsive to intimate partner violence under the theory that she could lead. But I wonder about then sort of going to this idea that the tables turned, sort of that the enforcement really did get more lax in the intimate partner violence situation, because what I'm thinking about is at the same time as there was women's liberation and change from Victorian norms, there were broad global changes in criminal law. There were these demographic changes that David Garland talks about. I mean, there were sort of racial changes. We had a ratcheting up and expanding of criminal laws, and just more people in the system. So I mean, I'm glad you're taking on this task, but I think it's such a hard task because, for example, now women come into the system without injuries, right? And so the even question of what is domestic violence, what are the people claiming have changed. So I just wondered, if you can comment on how you're going to be able to compare whether the enforcement tables have really turned and whether there was sort of a crisis of under-enforcement around the 70s and 80s.
Yeah, I'm not quite sure how I'm going to do it exactly. And your point is very well taken about changes in the criminal law. I think as I was explaining to you earlier this week, right now I feel a little bit myopic in my focus on changes in family law and other areas that are kind of outside my area, well, very much outside my area of expertise. And of course I have to put it in the context of changes in criminal law. That's why some mornings I wake up and think, why am I doing this project? Because it seems awfully daunting. But I mean, I think I'm going to have to do for the later part of the 20th century the same thing that I've done for the late 19th and early 20th, which is actually to go to the cases. I mean, there's so much talk in the legal literature that just cites to secondary histories that may not have actually grappled with the cases. And I think you've got to go and pull the actual court files and see what happened. Because I'm perfectly willing to be wrong about the fact that it did change. I mean, it's possible that we've gotten it wrong all the way up through the late 20th century, though, because there are plenty of people alive that can talk about how it was in the 60s and 70s. It seems less likely that we've just kind of missed the boat on what happened empirically, but I need to check that out. And I mean, I have to do it the same way I did the 19th and 20th, which is a lot of gritty work in the archive. Yeah. Alexia. I was trying to tell her, you're way back there. I was like, is that Alexia?
I have just one curiosity and then one question. I guess the first curiosity is, as you were going through your archives, did you notice any trends, or could you speculate on any trends geographically? I mean, do you see the same results with the intimate partner violence cases in California as you do, let's say, in New York? Are there any geographical differences? And then the second question has more to do with the relationship between
Mhm.
And I'm thinking, kind of is there some interplay between remedies in tort that may have resulted in some of the criminal violence? Like, and I'm thinking specifically with respect to breach of contract to marry and those types of tort claims that were made by intimates in that time when their partners went astray. They filed breach of contract to marry cases, and perhaps if they lost remedies there, they may resort to violence. And if you saw that at all.
Okay. Yeah. So, so let me see if I remember. Your first question was about the regional variations, right? Yeah. So as to the regional variations, I would say there certainly were regional variations. The dominant story was the same. So you see, vigorous, relatively compared to what we thought, vigorous policing of domestic assaults and convictions and severe punishments of men, acquittals or more lenient outcomes for women. That story is the same across some pretty diverse geographic regions. And the main thing I've looked at is the Northeast, focusing on New York, and pretty broadly in the American West. And of course, I had a little wild hair and whenever I did some work in Australia and pretty much found the same story in Australia. There were some interesting differences, though, and those I have tried to account for so far in my work. I mean, some of them were differences in the law. So, for example, first-degree murder was automatically a capital sentence in New York, where it wasn't in Colorado, and as you can imagine, there were fewer executions in Colorado. The life sentence was more common for these intimate partner killings in California. There were also some interesting social differences. And some of these I still feel, are a little bit anecdotal for me to be completely confident of. But in New York, for example, in this growing metropolis, I think there was kind of a pulling away from neighbors. It was less common for neighbors to call the police, when there was a domestic incident going on next door. Whereas in the West, there seems to have been a lot of intervention by family and neighbors. And one thing that's quite interesting in the American West is, in terms of sort of the rise of state intervention in the family, I think there's a good argument in the American West that in the intimate partner murder cases involving male killers of women, the state intervened to kind of head off popular violence, lynching, because there were actually lynch mobs that would gather and take a guy and hang him from a tree or try to get him out of jail and hang him in the West, which you don't see quite so much of in the Northeast. But I think in the American West, you really kind of see the state coming in to make sure it doesn't get out of hand, when it's driven by popular condemnation. As to the second question about tort, I haven't looked very much at the breach of contract to marry cases. I mean, there's some other interesting connections with tort that I found. I mean, for example, this is the time period in which interspousal immunity was alive and well. So women didn't really have any recourse in tort against their batterers. So that it makes sense that they had to try to get some kind of remedy from the criminal court if one was going to be had. And the other, I guess this is actually not tort, it's a criminal. I guess it actually was a civil case, even though it's called criminal conversation. But seduction was actionable, which I think makes my jilted women's cases more understandable. I mean, I think for us that seems like a huge stretch to acquit somebody because they shot someone who jilted them. But in the 19th century, it was a big deal to jilt your girlfriend, especially if she were pregnant. So those areas I've looked at. I haven't looked so much at the breach of contract to marry, but that's a great suggestion and something that I should look at. Yeah, in the back?
You had mentioned that the Victorian model of the archetype there occurred when juries consisted primarily of males or all males.
Mm-hmm.
And obviously that's changed. I'm wondering if the scholarship says anything about the correlation between the shift in the way these cases were treated and the presence of women in juries.
Mm-hmm. Yeah, I mean, it's something that I think is really intriguing because it's very counterintuitive. I mean, you would think that things would get easier for female abuse survivors as women come onto juries, and what I'm arguing is that I think they didn't. I think it was the other way. And I haven't really delved deeply into the criminal cases after 1930 yet. That's the part that I'm just working on, and as I was explaining to Professor Gruber, I've mostly been looking at the family law permutations, but that's definitely something that I want to look at because it's an interesting part of the conundrum. I mean, why is it, if things did get worse for female intimate partner abuse victims, isn't that ironic in a time when more women were serving on juries. I don't have the answer yet, though. Bill?
I was just wondering whether, as you're looking at this stuff, which is so rich, whether there was anything about, policing that struck you that was really different. We talk, I don't know, about community policing and patrolmen walking the beat in those days, and now, everyone's behind shields and in cars and things of that nature. Judges, I don't know whether it's obvious, but what you've seen so far, that they probably play a more active role in trials, or maybe have a little more authority than they do today. I don't know. Is there anything like that about those kinds of institutions that jump out at you when you say, that's interesting?
Well, as to the question about policing, I definitely think there's something interesting there about the rise of police departments as an institution, because what I think is the overly simplistic feminist story, essentially holds that the police officers were just sexist and they didn't care about the intimate partner abuse victims, and so they refused to do anything. And of course, the material I've studied shows that they actually did, show up and arrest the guys, or at least summon them to court. But I do think that to the extent that there was a pretty serious failure of prevention, another factor to consider was the undeveloped and pretty much lawless state of policing for a lot of the early time period. So it didn't necessarily have a whole lot to do with gender. It may also have just been due to the sort of unprofessional and brutal nature of policing, particularly in a metropolis like New York. I mean, the New York police in the 19th century were notoriously corrupt and disorganized and brutal. And so to the extent that they weren't, intervening in ways that from our modern perspective we might think are appropriate, it may have had something to do with that more than in a really simple sort of gender war that was going on. As to the judges, I'm not sure it was different, but I think the judge's role is interesting. So for example, in the Mae Talbot case, I'm describing that as a case where the unwritten law is working. And yet, one thing that does seem to be pretty catalytic in the trial was the jury instructions. But Judge Pike in that case pretty clearly goes off of the model instructions for Nevada. This interjection of gender into the self-defense argument isn't really something that was embodied in Nevada law. It's something he said. So he's kind of commenting on the case in a way that goes beyond what a typical set of jury instructions would have been. And I think that's quite interesting, though. I'm not sure from sort of a legal realist perspective that it's really that much different than something that might go on today. Yeah, in the back.
You talked a bit about the court focusing on people who show vices and not complying with the social Victorian norms. Did your research reveal any difference in prosecution rates across different socioeconomic classes or immigrant populations, any of that sort of thing?
Okay, yeah. Well, so first of all, I have to give a little bit of a caveat, and that is I'm rarely able to do anything that is statistically valid from a purely quantitative perspective, and that's because the data sets I have simply aren't amenable to that. It's pretty much impossible to figure out how many beatings there were and the social class of all the defendants. So there I have to just kind of throw up my hands and say I'm not going to be able to do super solid quantitative work here. But I did look at variables of both race and socioeconomic class. And my answer to the question on socioeconomic grounds would be I do think that the cases cut across socioeconomic grounds. However, I'd say that probably the bulk of the cases are poorer male defendants, and oftentimes male defendants who are just simply not cutting the grade under the 19th century standard of business achievement. So, I do think there is some socioeconomic bias there. And provisionally, at least, I've found some indications of race bias, though, I don't have anything that I can say conclusively on that point, but those are issues certainly that I want to take into account. Yeah.
So you mentioned that one of the underlying themes that hasn't changed historically is the idea that violence maintains control.
Mm-hmm.
And I was wondering if you've thought about if So your hypothesis about the change in the 20th century has to do with being less sympathetic to women because they've gained employment and political voice and the right to divorce. And I wonder if that has something also to do with, if the change has to do with just regaining control over women, both the individual partner who's being violent in a relationship, and maybe society generally. So women and male juries wanting to control women's role.
Yeah, I think that's a good point, and that's pretty much harmonious, I think, with what I'm arguing about the later period, about the sort of 1940 on, is that is what's happening, is that when I say the tables have turned, I think it's because women are doing things that seem more disruptive, in a deeper way to the social order than the way they were considered to be doing in the 19th and early 20th centuries, and that has a dislocating effect that produces differential outcomes in the criminal law. So I think that's very true. The interesting thing about it is you can't really divide it into two periods, when were the women were obedient and obeying the Victorian norms and when were they weren't. Because one thing is that there's some very interesting overlap. I mentioned this briefly at the end of the lecture, but didn't get into it very much. Of course, changing gender norms have an impact, I think, in the late 19th and early 20th century that initially tends to redound in favor of the female intimate partner abuse victims. In other words, first wave feminism starts to articulate claims about companionate marriage and about women's equality and the fact that they shouldn't have chattel status. And I think that does affect the outcomes of the cases in a way that is sympathetic to women. But the further that gets pushed, towards claims for the vote, claims for, equal pay in the working sphere, that type of challenge starts to become more disruptive. So I think whereas first wave feminism was helpful to female intimate partner abuse victims, when the challenges become a bit more concrete and vociferous in the 20th century, I think your argument is right, is that there is sort of a societal discomfort and desire for control over women that may be working itself out in the cases and in a change in the way the cases are treated. Yeah.
I wanted to ask, talk about sport and how they were treated differently. I'm wondering, is there a consensus about whether women who are violent against their partners are treated differently now than men are treated for violence against their partners?
Yeah, that's definitely part of my argument. And I haven't looked at that really so much in historical terms, as to sort of what's going on in the present day. I haven't looked, empirically at a whole lot of cases. But I think if you think of the criminal law in kind of substantive equality terms, in other words, we're not looking at what it says on the face of the statute, we're looking at the impact of the statute. Something like the extreme mental or emotional disturbance defense, that's a minority position with regard to mitigation for murder, but some 20 states have something like that doctrine. I think that doctrine does have a differential impact. And I think that impact is one that tends to spare men, to result in mitigation for men, because the types of homicides that seem to fit under that doctrine empirically seem likely to be the ones that men commit, which are essentially the separation killings, the control killings that Professor Kunin was talking about. Yeah, Marjorie?
Thank you very much for the talk. As a historian, I feel out of my depth here, but I have a question about work, women's work. And I think I would like to encourage you to think about that in a little more complex fashion as you continue your analysis. Because in the Victorian period, middle-class women were not supposed to work.
Right.
All working-class women worked.
Right.
And indeed, in several of your examples, you talked about how the fact it was the woman who was providing the means to allow their dissolute husbands to agree to. So I think there's a very strong class component in that earlier period. And in this country, that continued into the at least to the Depression and through it. And then with respect to what happened around 1950 and 1960, that I think that again has a slightly different cast to it because so many women did move into work during World War II. And during the war, they were complimented for doing that. And that was seen as a patriotic act. But after the war, there was enormous rhetorical pressure on women to go back home.
Right.
So the later 40s and 50s were really peak and well of domestic work. So I think that part of what you're seeing in that period is not necessarily a change in women's work in any longer pattern, but rather that more specific. So your broad argument that the shift in the later 20th century is due to changes in women's working patterns, I think that there's an awful lot going on now.
Yeah, that's a good point. I'll definitely take that into consideration. One thing I'd like to revisit with you, just sort of maybe outside of this forum, but I am interested in the sort of what I see as an interesting tension or puzzle in the 19th century. I mean, I know what you're saying about the working class, and it was quite common for the women to have at least some kind of labor that they did, even if it was just more sort of cottage labor, but some of them were employed in the factories as well. And what I think is interesting about it is what I've seen operating in the cases, and maybe I'm just reading too much in terms of social norms into the legal outcomes, but it seems to me that the men who were not living up to the Victorian ideals of the Christian achiever are, in the press and perhaps in the legal outcomes as well, at least that's my argument. They're really being slapped, whether they're working class or middle class, for not living up to that bourgeois ideal of masculinity. And certainly there was a sense that bourgeois women didn't work, but I don't really see, either the popular culture or the legal outcomes being punitive towards the working class women for working. I'm not totally sure to what extent you would have been able to completely support themselves and their families, and so maybe that's part of it, is that the labor they were doing wasn't really threatening. But it's definitely something I'd like to talk to you more about and to do more work on, because obviously it's a bit preliminary in the stuff I've published so far. Yeah.
Is there one more question?
Yeah. One more question? The dean says one more question. Yeah.
I'm thinking about the enormous increase, number-wise and percentage-wise, of crimes in general. I mean, there were very few criminal defendants. It was a big thing to have a trial, and the circuit judges used to go around because they didn't have a courtroom packed with people waiting for their court. That alone seems to me to be pressure for pleading guilty and, more cursory handling of the case, whereas today the police and the courts have more, so they're, as a numerical function, they're more likely to say, we're not going to prosecute them, or we'll walk them around the block, we won't take them into court.
Mm-hmm.
That's a different dynamic which seems to have perhaps equal probative value, explaining why we have these differences in attitudes.
Yeah, it may be good advice to continue my analysis of what's going on in the decision to accept guilty pleas or not as I move the research later in the 20th century. The one thing I will say, though, is that the rise of plea bargaining actually happened in the 19th century, not the 20th, although obviously it's continued in momentum and in its scope in the system in the 20th century. But actually, in the 19th century, that initial project I did was not supposed to be a project about domestic partner killings. It was actually a project about prosecutorial discretion in New York. And already in the late 19th century in New York, the dominant mode of case disposition was the plea bargain. And what I found interesting in that project was that although that was true, it actually tended not to be true so much in the cases of more serious violence, and I think that was because the public simply didn't support it. The public wanted trials on serious. They didn't want to hear that a murder case was pled out to manslaughter. I think that was very strongly true of the 19th century public. But interestingly, despite the fact that there was a lot of case pressure already in the late 19th century for plea bargains rather than trials, due to an increased docket, although it was mostly the increased docket on the civil side, putting pressure indirectly on the criminal side, it still seems that these intimate partner killings went to trial, they weren't pled out. And that's kind of where my whole research in this area started, was looking at that and then having this sort of unexpected finding about the intimate partner killing cases.
Well, Carolyn, as usual, this is masterful, interesting, and thought-provoking. Thank you so much.
Thank you.